the State Bar of Texas, which obviously is the governing body in the great state of Texas, over lawyers, they have, CLE, continuing legal education, and the sort of pinnacle for that is the advanced course, whether it's in personal injury law or family law or what have you. It's the advanced course, and almost every year I get asked to speak on a topic, which we do unpaid, unrewarded, without a lot of pomp and circumstances to it, but it's to do exactly what you suggest to help other lawyers better their craft. And as I said yesterday when I spoke at the advanced course, I'm always a little chagrined to speak of the advanced course because it's not just criminal defense lawyers. It's
prosecutors.
It's prosecutors and judges. And I always think to myself, why am I telling prosecutors and judges what I do and how I do it? Not that I'm Nick Saban, but not one time did Nick Saban hold a press conference before the game on that next Saturday and say, here is what I'm going to do. So you're educating the enemy to a specific instance, but that is what it is. And good prosecutors speak. I learn, I get to peek in their kimono or look under their tent or whatever you say as well. So it's a nice collegial professional experience. To me, I love cross-examination, and it's why I became a lawyer, right? I wanted to be a lawyer that got into the courtroom, and I knew that practicing criminal defense would get me into the courtroom. And so we can walk through it slide by slide or whatever you want to do.
Yeah, I want to go through it slide by slide because, again, I find this stuff very fascinating and have an appetite to learn, even though I don't want to be a lawyer. I'm not going to, but it's still really, interesting stuff, especially cross-examination. I mean, that is what you see on, Law and Order and all the suits and all the, law shows that you see on TV, but it's a performative, written, scripted version, not the real deal. And so I do want to see more. And before we jump in, I want to kind of get back to what you just said, Dan. So you don't get paid to do those things. So a lot of the perception is, there's a price tag working with the criminal defense attorney. They'll do anything for money, but this you're not doing for money. So you just do it for the love of the game, or what motivates you to give back like that?
Well, first off, I think all lawyers have a responsibility and a duty to the profession to help others, right? I can't talk. You'd think I could talk better after 42 years. But as I said at Mr. Haynes' funeral, if I'm tall, it's only because I stood on the shoulders of a 5'7" giant. I mean, the only reason, or a huge reason, not the only, but a huge reason, the largest reason that I'm good at what I do is because I learned from a master. There's absolutely no way I would be as good at what I do, however good or bad that is, without having learned from Mr. Haynes. And Mr. Haynes had, if I heard it once, I heard it 1,000 times. And the expression was this: make sure you leave the playground in a better condition than it was when you got there, right? And that was his way of saying, dude, it's our obligation to make shit better, not just use it and walk away. And I believe that. I truly believe that.
No, I love that.
That ties back into making your bed, right?
Absolutely,
yeah.
100%.
No, I think it's important. I mean, I would be honored to be, even being a part, me and Tommy being a part of this. And if anything that we share here or prior lessons and learnings reaches someone who gets inspired and, follows this craft and later makes a huge impact, and we're somehow weirdly a part of that is pretty cool. So
I will tell you guys that the applications to become an intern or a law clerk at my firm have absolutely skyrocketed after we began this podcast. I used to get 1 or 2 a year, right? I've gotten 50 in the past couple of months.
Not surprised. I mean, we get a lot of DMs of kind of aspiring students that are really curious, should I go to this school? Should I go to that school? Mr. Cogdell, what do you think about this? What do you think about that? Which is pretty funny.
Should I really not apply to A&M?
Let me stop there. I love A&M. A&M is a great school. They have a wonderful law school. It's not good. It's great. It's like a top 20-ish school in the country, which is remarkable because they've only had it for 5 years. They're doing a kick-ass job. They're doing a great job. But I'm a UT guy. I'm going to stoke the rivalry. I wasn't serious about the Aggie. And there are a lot of butthurt Aggies out there. I mean, the dean who I really like. He sent me an email saying, I can't believe you said, and he knew it was tongue in cheek. He said, I can't believe you said that about our law school. I agree with the first four, but did you really have to? So I emailed him back. I said, come on, he said, no, I got it.
That's hilarious.
That's hilarious. To the dean.
The dean of the, and full disclosure, I said, hey, Dean, you know I love A&M. No bullshit. I didn't say bullshit because I'm writing to Dean. I said, I'm dead serious. If you want somebody to come teach trial ad, I'm all in. Consider this as an application. So I'll teach there. It's a great law school, but I got to give the Aggies shit because they deserve it. They got male cheerleaders. Get rid of the male cheerleaders.
It's always hook 'em over gig 'em on this side. It's always hook 'em. But man buns, do you love man buns too, or is that?
No, I do not love man. You know what the definition of an Aggie menage a trois is, right?
What is that?
To watch. Do the math.
Oh God, that's hilarious. No, I mean, it's powerful, man. Like that's the thing about it, the influencing space. And to go back to what we started this whole conversation today, today's episode was that, the power of influence, curated to, something of substance and of teaching, which your platform is shaping to be. Obviously you troll, obviously you have fun, you self-deprecate, you mess around. That's kind of part of just who you are. But overall it's kind of to teach, and it's to teach at scale. Like, how many people go to these CLEs?
Oh, there were probably 300-400.
300-400, which is a pretty decent size, but it's not 50,000, right? So, ultimately, you're going to be reaching more of an audience here, whether it's tailored to, who wants to see this stuff or not. Eventually, it's going to find that crowd. So, kind of talk us through this, and I'll just go from slide to slide, and kind of on your through your direction. So I'll let you kind of take it. So the first slide is here. Why did you become a lawyer?
Yeah.
Can you talk us through?
I became a lawyer because I wanted to try cases. I specifically became a lawyer because I wanted to try criminal defense cases and work for Mr. Haynes. But specifically as a criminal defense lawyer, it is cross-examination where you make your money, right? Because oftentimes the facts aren't on your side. You're not building a case so much as trying to destroy the state's case. So it is just that. You make your money on cross-examination, and if you're not a good cross-examiner, you are not going to survive in the criminal defense world. No, so the most important tool, in my view, in the toolbox of a criminal defense lawyer is cross-examination.
Got it.
So it takes three things. As I referenced earlier, it takes experience, and we'll get. And I misstated the number, Tommy. It's 1,200 times that the Beatles played in Hamburg between 60 and 64. 1,200 times.
That makes more sense for every other day.
I misspoke. Yeah. Even me makes a mistake frequently, but it's experience, it's preparation, and it's execution. You got to be able to effectuate all three of those things.
Is it ever a case that you can over prepare, or is it?
No.
You can never over prepare?
Now, there are, look, and we'll get into this, but I have cross-examination A, cross-examination B, cross-examination C. Depending upon where the witness goes, I will have another outlet for me. There are some lawyers, like my friend Rusty Harden, who's Rusty's natural skill set, just God-given skill set, is outside the bell curve. I've never seen anything like it. Is he the very best cross-examiner I've ever seen? He's top 2 or 3. I think all of us have good days and bad days. But my point, Aaron, with him is he doesn't prepare. If he does, no one ever sees it. I mean, he has great assistants and associates that give him these 3-ring binders like that are highlighted, color-coded, cross-referenced. Just these wonderful outlines. And he might look at him doing a 2-day cross, and he might not. I mean, his instinct on where to go exceeds any normal human's ability to prepare, right? It's just guttural instinct. And the difference, I say, and I'm getting a little off topic, but Mr. Haynes, he would cross-examine a witness for 2 or 3 days, right? And he was looking to destroy the state's or the government's case in every little way he could. They were always just paper cuts, right? There was never any head that got cut off or any femoral artery that got severed, little bitty paper cuts. But by the end of a 2-day or 3-day or 4-day cross, they were bleeding out. Rusty's completely the same, yet exactly the opposite, meaning he will do a 2 or 3 or 4 day cross-examination, but instead of destroying the state's case, he's building the defense's case, right? And those are two different directions. Sometimes you can head fake one and go to the other, but it's like, oh my God, it's just the exact other side of the coin. Their skill sets were comparable, but Richard is destroying while Rusty is building. I'm more of a destroyer, and I like to think I'm a little chameleon-like, that I can change depending upon the course and the case and all that. Haynes never changed. He was always going to destroy. Dick DeGuerin, who's a great lawyer, great cross-examiner. Dick is always attacking the state, always lying cops, cheating cops, overcharging prosecutors. And it works, right? You can't argue with Dick's success rate, but it's not me. I can't do that hate the cops, destroy the cops, lying cops shit all the time. I'm not good at it. Dick is. So my point is, it's all those things: experience, preparation, execution. I don't think a normal lawyer can ever over-prepare. I think we can get too tired and get lost in the weeds of our cross and not listening to what happened, but I don't think you can over-prepare. It's like a surgeon over-preparing for surgery. How do you do that?
Yeah, that makes sense. Do you feel like being the destroyer like that? I mean, you gain a lot of enemies doing that approach, right? Or
I have gained a lot of enemies. I have 3 ex-wives. I have plenty of enemies. You've got to use that destroy sort of mentality sparingly. And if you try to destroy every single witness, you're just an asshole.
Exactly.
Right? You destroy the ones that need killing. You don't destroy. You might not even touch the ones that don't hurt your case or don't hurt your case that much. I believe, and again, it's just my personality, I believe I've got to make some concessions, right? I acknowledge my weaknesses. I acknowledge the strength of the state's case on this, that, or the other thing, right? But I think that's a positive. I'm not a good liar. I'm not, right? And I think whether I'm right or wrong, I think if I'm lying or I'm insincere, a jury's going to smell that. They may not cognitively be aware of that, but it's like, why is that guy getting red in the face? Why is he stumbling when he asks the question? Why is he shuffling his papers? Why is he looking down? And I think juries are masters at understanding the essence of something without perhaps even cognitively appreciating, what they are recognizing internally, or if you will. So I make fun of myself all the time, because I think you need to, because that's part of who I am. If I came out and told, the whole world I'm the greatest lawyer that ever took a shit, you're so lucky to, what is that? I have strengths. I have weaknesses. Everything does. So I think sometimes it's important to realize this witness was very credible. I probably believe them too. But there are other witnesses that weren't so credible. And you've got to take the government's case as a whole, not as a single piece. So let's look at it as a whole. Yes, let's give Mr. Smith his accolades about being truthful. But look at Agent so-and-so, and look at Officer B, and look at Witness C. You add them all up, you ain't getting on that Southwest Airlines, or whatever the adage would be.
Yeah, so doesn't it help you with your credibility if you're not always like picking somebody apart?
Yeah, absolutely.
Yeah.
But again, guys like Dick never acknowledge a weakness, never acknowledge the strength and do it well. But I'm not Dick, and he ain't me.
It's almost like Kobe, like you said, that Mamba mentality is just to attack, be on the offense constantly, and win by pure force. We'll get to Kobe. So we'll talk about experience.
And again, it's Malcolm Gladwell's 10,000 hour rule. And I misspoke earlier. The Beatles performed 1,200 times between 1960 and 1964. That's almost every day. Jordan, 5 hours a day with his trainer. That's in addition to the Bulls. Kobe, 5:30 and 7 p.m. in high school. And people got me all kinds of shit. You don't really work 60 hours a week or 80 hours a week, and your wife's probably screwing the pool boy and all that stuff. First off, we have a pool woman, but that's another story. But the point is, I do have to work that hard because I'm not a quick study, right? I'm not. I had a smoking hot 2.6 from the University of Texas. I wasn't a Rhodes Scholar. It took me a minute. I had a hell of a good time, but my windy point here is I have to spend the time because it takes me the time. Because if I want to appear and be natural and confident, I have to know it cold. And a jury can smell it when I walk in the room if I'm not prepared. I don't like that feeling.
That's awesome.
So there's a guy named Irving Younger, and these rules came out, or these commandments came out probably 50 years ago, and they are as true today as they were 50 years ago. The 10 Commandments: be brief, use plain words, use only leading questions. In other words, you don't ask a witness, what time was it? You ask a witness, it was 10:01, wasn't it? Right? There's a difference. Be prepared, as we just talked to. Listen, if there is a failing in most lawyers that I see on cross-examination, they are more focused about listening or uttering their next question than they are listening to the answer. They'll look at their next question. Sometimes a gem floats right by them that they don't hear because they're not paying attention. They're focused on their next question. They're not focused on the answer. And of course, a answer can absolutely pivot where you go completely, but they're not experienced, they're afraid, they're not prepared, so they're just sticking with their outline and not listening. Don't quarrel with the witness. Again, I like to argue. It's not about arguing, it's about persuading. Avoid repetition. I disagree with that one a little bit. In the year of our Lord 2025 with iPhones and all of that, because I think people's capacity for recall is less now than it's ever been. I think you have to repeat because people don't hear it the first time. Disallow witness explanation, we'll get to that. Limit questioning essentially means don't ask a question you don't know the answer to. And the final is save or summation. The highlighted ones are the ones that I see disavowed the most.
As in, like, people just screw that up.
Yeah, they screw it up.
The avoid repetitions too, like you said, even when you did the example a few minutes ago of the closing statement, you repeated yourself.
Yeah.
And I remember it felt even more powerful the second time
Right.
you said it. So I think that would be an example of repetition, right?
But it's, like you said, delivering that message, because people kind of need to hear something twice or three times now because of how, overstimulated and, unable people are to really retain anything now with the age of social media and
it's
and
worse
phones.
than that, respectfully. You can say anything you want. You can tell a person they're an absolute asshole if you say, with all due respect, before you say that. That's the law. Yeah. But respectfully, it's worse than that, because I think now more than ever, people make up their mind immediately, and it's bias confirmation or confirmation bias. They come in, they hear an opening statement, or they come to a conclusion, and they just selectively hear what they want to hear that buttresses their already made up mind. And in cross-examination, it's hard to get them past that confirmation bias by asking a single question, right? And I'm such a cheap shot artist. If I get a really good answer and I'm on a roll, I'll pause after it. If, for example, the witness says, upon reflection, the lighting, it really wasn't that good. So and I'll pause and I'll say, and we'll get to this, the pause, and I'll say, wait, say that again, which is completely objectionable, right? Because objection repetition or objection repetitive, but the theater of it, to go to your earlier point, almost every time a prosecutor's caught flat-footed and go, oh, shit, I don't want to, oh, shit, and they'll say it again. So I've got a golden answer twice because I'll pause and get them to stop the room. Say that again. It's a wonderful
That's actually brilliant. That's crazy. I'd love a graphic, of maybe Dan, your own, I know this is Irvin Younger's, but if you had like Dan's commands or Dan's Elite 8, tools for cross-examination, and the graphic on the screen like that, that page does would kill for a clip. Cool. Going into format.
Yeah, so format, this is just sort of the order that I think lawyers should pursue. And you always want to get just about every witness, no matter if they kill you or not, they have something favorable to say. So my point here is, if there's anything favorable, get that out first, right? Because A, it's safe. You can create your sea legs on cross-examination. And B, why do you want to impeach them first and then get the good stuff out? It's contradictory. And in any cross-examination, you're probably 30 or 40% of it's going to be uncertain, meaning you don't know what the answer's going to be. So this is kind of an exaggerated version of primacy and recency, right? You take your risk in the middle of the cross-examination, so at least you start favorable and you end favorable. In criminal cases, as we've discussed, we don't have depositions, we don't have requests for admissions, we don't have interrogatories. Our discovery is virtually non-existent in the formal sense. So despite the adage that you should never ask a question you don't know the answer to, in the criminal cases, there's a lot of questions you're not going to go to the answer to. My point is there, put the uncertain stuff in the middle. The kill shots at the end, the ones that absolutely you think you'll have the witness on the wet end of the spear on that, put them at the end, and most importantly, know when to walk the fuck away. If you've made your primary point, even if it comes up at the very beginning, and you've got a lot of less important shit that you think you need to, walk the fuck away when you're winning. If you get a high, and similarly, sometimes if you're getting killed, you just shouldn't keep poking that bear over and over. That brown bear is going to kill you. Walk away from the brown bear. So know when to walk away.
So I know this is a format for cross-examining, but I'm reading this and I'm thinking, shit, man, this is a format I could use when I have arguments with my girl, because I definitely struggle with the last piece of knowing when to walk away.
Well, Aaron, you know as well as I do, there's only one man that's ever won an argument with a woman, and that's Johnny Depp. I mean, you want to be right or you want to be happy? Pick a lane. In voir dire, jury selection, or opening statement, and argue that a witness lied. They don't have to be a liar for me to prevail. They have to be mistaken or wrong, but there's a difference between intentionally telling a lie, which is knowingly stating a false fact, versus making a mistake or being wrong. The analogy I always use is an air traffic controller. If an air traffic controller is giving the wrong information to a pilot, if he's lying, the plane's going to crash. If he made a mistake or was just wrong, guess what? The plane's going to crash. I don't care if it's a lie or a mistake or simply being wrong. It's still fatal. So why are you setting the bar so high that you got to jump over it? No, I don't have to show that he lied. I don't have to show anything technically, but I shouldn't even suggest that I'm going to show that he lied. Now, sometimes in the rare case, you got a situation where you can absolutely show, based upon a prior sworn statement or a video or whatever, that a person's lying. Well, if it gets you all plumping hard to go there, well, then go there and say, oh, they lied, they lied, they lied. But in almost all other situations, which are the vast majority, don't say, suggest, or intimate that you have to show that a witness lied. No, they were just wrong. It's a French. I think in French it means to speak the truth, but in Texas we call jury selection voir dire, right? I don't know why we do, but we do. And fun fact for those at home who probably know this anyway, it is not jury selection, right? The lawyers do not say, I want you, I want you, I want you. We don't choose. In no jurisdiction are jurors chosen. It's a process of survival, not selection. We eliminate you, you, and you, and the first 12 people that aren't eliminated are on the jury. It's jury survival, not selection. So, and inevitably what happens, and getting off topic a little bit from cross-examination, but inevitably what happens, and there are now AI programs that you can use for jury selection and mock trials and focus groups. It's crazy stuff, but in the real world, most of the time, what generally happens is the 12 or 14 with alternates, people that say the least and you know the least about, those are the ones that end up on your jury, because the ones that you know the most about, that you dislike the most, you're killing those. So it's a bunch of unknowns. Usually, you know, because each side has X amount of peremptories and whatnot. A peremptory challenge means, in a felony case in Texas, each side has 10 peremptory challenges, meaning you can get rid of those jurors for any reason at all. They're free strikes, right? You cannot eliminate them based upon race and protected classes and all that sort of stuff. But generally speaking, dude, he looked at me wrong. He rolled his eyes. She hates me. I can just tell by the way she walked past me when I was going to the back. Whatever. You can get rid of them for any reason at all. So my point being, long-windedly again, is you end up with people you don't know anything the hell about. Theater matters. We talked about this just a few minutes ago, but the you know, you vary your tone, you vary your pitch. Roll the next one. So Rusty, my friend, and certainly one of the greatest living trial lawyers. Rusty, don't want me to tell you his age, so I won't. But he's older than me by 14 years, so I don't want to tell you his age. And I'm 68. But he is so good at varying his tone, and I'm pretty good at it too.
You're good.
And I do the same thing, and I learned it from guys like Rusty. What a judge wants you to do is stand behind that lectern, right, and not move, and just sit there at your desk or stand there behind the lectern and not move. Ask all your questions from a seated position or from a standing position chained to a lectern. You know why they want you to do that? Because it sucks. Jury's not going to follow you. They're not going to pay attention to you. I move as often as I can, right? We are mammals. At the end of the day, if a mammal detects movement, guess what it does? It follows the movement, right? So I move around all the time, not because I'm trying to get my steps in, but because I know a jury will follow me, right? And if I just sit there, or if I just stand there handcuffed to the lectern, I'm not as interesting. I'm not that interesting anyway, but I'm a little more interesting, you know, when I move around. The most unused tool in the courtroom?
I like that.
Pausing. It is so powerful. When all the noise stops, you pay attention, right? You just do. I mean, travel down the highway. Just get in your car, go anywhere, turn on the music, turn on the windshield wiper, turn on the air conditioner, turn on as many noise creating things as you can, and try to think or try to experience or try to be present. You fucking can't, right? Stay in that same car. Turn off the air conditioning, turn off the windshield wipers, turn off the music. Guess what you're going to find? You're present, and you're paying attention to how you feel and to what's going on and to the traffic. And it's the same with using a pause in the courtroom. It literally focuses you on what's going on, and everything else is just a distraction or a diversion. You can't use it all the time. You got to say shit. But if you pause, sometimes you get people to focus better.
Damn, a pause can be so powerful.
Oh, it's wonderful. It's like that wife or girlfriend. Hey, honey, I'm home. Oh, that pause, it ain't ever good. It is never good, and you are paying attention when you get that pause. It's got to be organic, and it's got to flow, right? If you do it more than really once per witness, then it just becomes a gimmick. Right? It's like, oh, this fucker thinks he's going to get us to pay attention by pause. What the fuck ever, right? It's got to flow. It's got to be organic. It's got to be. I put my friend David Gerger up there because he is so effective at that. I call him a master pauser. I said that right, a master pauser. But David is very cerebral, educated from Yale, UT Law School, kind of very highbrow, sophisticated. used to be a little condescending in my view, but now he's much more comfortable in his skin. He's one of my top 2 or 3 guys I'd hire if I was in trouble. He's a brilliant guy, and he is the master of the pause. But it works for David probably even better than it works for me, because he is a little holier than thou. He is a little cerebral. So it's that professorial. Is that really your answer? You know, I can't do that, right? I would do, is that really your answer? Really? But David does this. Is that the best you have? You know, and again, it's personality driven. He can do that shit. I cannot.
Got it.
Right?
That reminds me of the comedian Dave Chappelle, right? I think what makes him probably one of the best comedians is his effective pausing.
Yeah.
And that really sets him apart. I mean, not that, you know, I think that's like one of his best attributes. So it's effective in comedy. It's effective, you know, in all realms.
But you look at, you know, I don't know who else you know, Ron White is at least as funny. I think both those guys are sort of on my Mount Rushmore of comedians, whatever. But he's not a big pause guy.
Exactly.
I mean, he'll do that.
Yeah.
But that's more of a. I think you think he's thinking of what he's going to say as opposed to a pause. I was thinking before you guys got here, you know, if I was ever asked what would you be or what would you want to be if you weren't a criminal defense lawyer, it'd probably be a stand-up comedian, because I think the skill sets are very consistent and interchangeable. You have to get people to pay attention. You have to be able to capture large amounts of information. Mm-hmm. You have to be able to pivot and go where the audience takes you, much like where a witness takes you. I think those guys are just geniuses.
For sure.
I have no idea how you can stand up and do an hour-and-a-half set.
Yeah.
I mean, I know how the Stones do it, because Jagger's here and Keith Richards is there and Ronnie Wood's, and this was playing and that was. But how you just stand there and deliver that shit for an hour and a half is amazing to me. You have to be able to, at least I do, you have to inject some humor into it. I believe, rightly or wrongly, that a laughing and a smiling jury is an acquitting jury, and an angry and a silent jury is a convicting jury. I think there's a lot of truth there. But just like anything else, like the pause, like the this or that, you can overuse it. But I've been known to say some really outrageous, borderline contemptuous shit in a trial, just to break up the rhythm. And what I'm trying to say when I do say something punchy or funny is, look, we're all human here. This is a hard racket. We have to take our humor where we can find it. There's nothing wrong with that. But more important than any of that, we're all human. My client's a human. Come on, let's ease up on the seriousness and the pomp and the circumstances here. Because when you're in federal court and they bang that gavel, hear ye, hear ye, hear ye. The United States District Court for the Southern District of Texas is in session. God save the United States. You know, and everybody's, holy shit, I'm going to prison now. You know?
I didn't even do shit, and I feel like I'm about to get locked up just hearing you say that.
Hear that, you're just like, God damn. And you think they do that not knowing the effect? The fuck, they don't know the effect. They love that effect. And I always send my clients, in federal court particularly, to go in and watch another trial, because they think, I got this. I watch, Perry Mason, or I watch Suits. Or it's like, no, dude, you don't understand the pomp and the circumstances of a federal court and how it's not in your favor. None of that shit is built to, and again, like we referenced a while back, when it's the United States of America versus you, it doesn't feel like a fair fight. It's not.
To add a little bit, if you have one in mind, can you give like one of the more memorable times where you got the lighten the mood in the crowd,
sure,
in the courtroom?
So in the Enron case, and we had a very patrician federal judge. His name is Ewing T. Werline Jr. And again, Tommy, you call Central Casting and ask them to send you a federal judge. They send you Ewing T. Werlein Jr. He's about 6'4" at 80 years old. He has this beautiful mane of white hair. You know, he just has all this presence, and he talks like this. All right, Mr. Cogdell, you have anything to say? I mean, it's like, holy shit. It's kind of like a white Morgan Freeman voice, right? It's where to get your attention. And we were talking about discovery, right? And we got into a discussion about whether or not the government had given us all the discovery. And some of this was this particular thing was not in the presence of the jury, but this lawyer, well, Judge, we got 3 megabytes, we got 2 terabytes, and this is 20 years ago. I didn't know terabyte from a partridge in a pear tree. And he said, Mr. Cogdell, how big is your discovery? And I stood up and said, Judge, I don't know all this terabyte and megabyte stuff, but mine's about this big. And the entire place just erupted, because the obvious phallic references, But the jury wasn't there. And it's like, all right. And if I were on the bench, I'd say, that's not what I've heard, but carry on. But it lightened the mood, and it got us to where we wanted to be, because we were talking about needing a short recess to come back the following day, and it just and he was kind of like, okay, fine, I'll give him the afternoon off or whatever it was.
Well, then on the other side of the coin, has there been a time where you've try to deliver a joke and it's like crickets?
Sure. Yeah, and when
you pivot hard,
when you fall flat and you're waiting for that, you pause that delivery, waiting for the laugh, and it doesn't happen, you're fucked. It's happened a couple of times.
Not guilty immediately. I mean, guilty immediately.
Yeah, but it's like it's like that moment in My Cousin Vinny where the stand-in lawyer's like, I'm getting better.
I know.
It's one of those moments you're like, oh, shit. I thought you said he was good.
The Curb Your Enthusiasm song starts.
Just like camera pans out.
Yeah.
Oh, that is so funny. Okay, so I got the next slide here. Runaway witness.
Yeah, so it's not uncommon at all in my racket to particularly with law enforcement. They just want to run away from you. They want to give you information that's not called for in your question. And so you have to control that witness, right? You have to rein them in. So you generally start off on cross-examination by saying, Special Agent Smith, let's make a deal. I will ask you simple questions that can be answered with a yes or no or with a short answer, and you will give me an answer that's responsive to my question. Is that fair? And what are they going to say? No. And they say, sure, well, if I can. But once they start running, right, once you ask them what time it was and they start talking about your client's Ferrari, Special Agent, do you remember the first question I asked you about me asking you simple, direct questions and you give me simple, direct? Yeah. So who told you to just add in information that you wanted to that wasn't called for my question? Did Lawyer Smith with the government, he didn't tell you that, did he? No. Well, did Lawyer Jane? She didn't tell you that. So to be clear, when you start adding this information in that's not called for by my question, that's your idea. That's on you. This is what you want to do, right? Well, I wouldn't put it that way. Well, how would you put it? Well, I'm trying to be responsive to my question. Well, what was the question that I asked you? Well, I don't remember. So if you don't remember the question that I asked you, would you do us all the favor of simply saying, Mr. Cogdell, can you repeat your question? Is that fair? Okay, fine. It takes a few of those to get coming and going, but they will run. They are literally trained at Quantico, where the FBI Academy is, to answer questions that ain't asked for, to run over you. They literally go to witness school, and this is a little overstatement, on how to lie, cheat, and steal, right? And I don't mean that disrespectfully, but they're taught how not to answer questions the same way we are taught on how to ask questions. And they're a professional witness. They will kill you, right? And that's the one thing about cross-examination. If you do it right, your client could be acquitted if you do it wrong, and one question, one bad answer can earn your client 20, 30 years in prison. So it's a very high wire you're on cross.
Wow.
That's actually crazy.
It's intense.
Man, this is so good. I mean, we can keep going now, I say.
So I see this all the time. It is when they testify for the state, they're Einstein. They know every answer to every single question, right? There's never hesitation, complete command of their memory on the facts. I get them on cross, and it's Sergeant Schultz. I know nothing, right? Over and over, they don't know, they can't remember, they're not sure, and it happens and it's just so stupid when it happens, but you've got to let it happen, right? You've got to let them say, I don't know, I can't remember, I'm unsure, and then just go to the next slide. What you'll do, or at least what I do, why is it easier to answer the government's questions than it is to answer my question? Has anyone suggested you to say, I can't remember, I don't know, if you simply don't want to answer the question? What can we do to help you with your memory? There's no right answer to that, right? Whatever they say is going to bite them in the ass. I love this one. I'll tell you a side story on this. Is there a medical or psychological basis, like medication, that affects your memory, right? I had a physician who was cooperating with the government on a case a few years back, and he said, well, I'm taking Seroquel or whatever it was. And I said, well, doctor, are you suggesting that Seroquel can impact your memory or impede your ability to recall? Well, I'm not sure. Well, you're a physician, right? Do you have a PDR app in your phone? Well, I do. Well, why don't you take it out and read it, right? And the government could object, but they're not going to, right? Because A, they look like an asshole, and B, they're hoping that it doesn't impact their memory, or if it does, whatever. And so he starts reading it, that premature ejaculation, inability to maintain very quickly into his side effect discourse that he's reading off the PDR. And at that point, it was over. I mean, everybody in that courtroom, the only thing they could remember about his testimony was that he prematurely ejaculates and he can't maintain a hard-on. I mean, it just, whatever credibility he might have had just went, I'm sorry to say, limp.
War story number one.
Okay, so that was the Kahanic trial, the Enron trial, where I got to throw my arm out of socket, pat myself on the back. I got the only acquittal in any Enron-related trial, whatever. But in Sheila's case, there was one phone call that was the alpha and the omega, right, of the conspiracy. And it was on this phone call that the conspiracy sort of began and gained legs. And there was a huge debate as to who said what and what exactly was said on this supposed conspiratorial phone call. And the trial was in like 2002. This phone call was supposedly like 1996, right? So 6 years before. So this woman comes up, and she is an ear witness, right? But she recalls everything, right? Well, Mr. Skilling got on first, and Mr. Lay got on second, and Jeff's Andy Fastow got on third, and Miss Kahanic, and Mr. McMahon, and blah, blah, blah. And just, it's like, what? You remember who got on the phone call? You remember exactly what was said by whom? You remember the details? This is 6 years. I mean, total recall, right? Just, it's complete and utter bullshit, right? There's no way you can remember that stuff. So I'm thinking, well, first off, when I heard her direct, I'm like, we're done. She has absolutely killed us. And we were doing really well up to that point. I'm like, okay, we're cooked here. So you got to take risk. So 6 years later, I'm like, all right, well, you have an incredible recall, Miss Smith, right? Just amazing. I do. Okay. Well, what day of the week was it? I don't know. Wait a minute. You remembered it was Lay and Skilling and Fast. Well, you don't remember what day it was? I do not. Well, how old were your children? She got to walk it back. You had to think about how old your children were, but you knew the order of the time that the people got on the call? Yeah, took me a minute. Okay. What did you get for Christmas that year? Well, that's not a fair question. No, ma'am, it's a very fair question because you remember with identical detail who said what, when, where. Who won the Super Bowl that year? Are you a football fan? Yes, who won the Super Bowl? I don't know. What was the most memorable thing that happened to you that year? The most memorable thing happened that year. It surely wasn't this phone call. Tell us 3 other memorable things. Long pause.
Damn. Savage.
Okay, so we've seen this,
Yeah.
but probably ought to play it now anyway.
Can I play this?
Yeah.
Oh, shit. Yeah, I want to play it.
So before you play it, so this is a video taken by a woman who would be shot by the fella pointing this gun at her. So play it.
You really want this on video?
I'll pull it. I'm mad enough to pull it.
Your neighbors are gonna see you pointing a gun at me.
I'm ready to go. Drop the phone.
No, I'm not. No, I'm not.
All right, goodbye, Reese. Nice to know you. You go meet Jesus.
Oh, shit.
Okay, so the point of this in my lecture to the advanced course at the State Bar yesterday was, how do you cross-examine the uncross-examinable, right? It's an audio. You can't cross-examine the audio and the video. It's coming in. So how the hell do you deal with that, right? Well, there's a few ways to deal with it. The first is you have to prepare the jury in jury selection and an opening statement. This is the worst piece of evidence you will ever hear or ever see in your life. It's awful. And again, some lawyers were suggesting, well, she just stood there when he was pointing the gun at her. She could have run away. No, that's not really a great defense that she could have run away when he's pointing a shotgun. Well, maybe he didn't intend to kill her. He just wanted to scare her and it accidentally. No. So my point is apropos, Aaron, to what I was saying earlier, you got to admit it's awful. Right? You can't run away from that. It stinks up not only the witness stand, the whole damn courtroom smelled like a urinal, right? Mm-hmm. An unflushed commode. That shit was everywhere. It was awful. So what you have to do is tell them you're going to walk into a bathroom where the urinals are overflowing and the commodes are overflowing with human shit. It's going to smell awful. It's going to be terrible. And I want to tell you that up front. I'm not going to mislead you saying they weren't overflowing that much or that the refuse wasn't that bad. It was awful. But you're not here to judge, the plumbing. You're here to judge the plumber and what happened to the plumber that day and days before it, right? So let's not talk about the feces. Let's focus on the plumber, meaning Carrie, right? And I thought that was kind of trite, but kind of effective at the same time. So what the focus became, first off, you have to normalize it. You've got to play. The first time you see that, you're just like, oh my God, that's the worst thing I've ever seen. The second time you see it, it's equally offensive, but a little more understandable because you know what's going to happen. The third time or the fourth time or the fifth time, you think, well, she does kind of sit there and she could have run away and she does kind of taunt him, but you don't point out any of that shit, right? You just make them play it 2 or 3 times. And detective, I'm not sure it's horrible. I hate to do this to you, ladies and gentlemen of the jury. I apologize in advance, but I want them to understand the nuance of it. Could you play it again? And you don't ask the officer, did you see her not run anywhere? You just let the jury figure that stuff out, right? And then at the third of it is, you just deal with it. Meaning, in this case, next slide, Aaron, you point out what happened before that, right? And after that, because before that, she secretly tape recorded him where she's, they were swingers, whatever, and she was taunting him, basically saying, of course I was screwing that other guy better. he's better hung than you. Nobody wants to fuck you. You're a fat piece of shit. You don't provide for me anymore. You were broke. When we were first married, you were rich. I mean, just every single horrible thing you can say about a man. And as I argued to our 12 women on the jury, 12 women, I said, listen, all of y'all know this. Every single one of you know this, regardless of married, single, orientation, whatever. If you really want to upset a man, if you really want to get him angry, if you really want to get him in a passion, and a bad one, talk about his inability to perform sexually and talk about his inability to provide financially. That will upset any man on the planet, including the one that's talking to you right now. You know that, and I know that. So let's view this for what it is. It's a horrible tragedy. That should have never happened, but it is also, under the law, a sudden passion arising from an adequate cause. Did she deserve to die? Of course not. But was this a cold-blooded murder that didn't involve sudden passion from writing an adequate cause? Of course not. Does he deserve to get probation? No. The law doesn't even allow that. But he deserves to be, this case, all I'm asking you to do is follow the law. And the law is, if you believe by even a preponderance of the evidence that it was sudden passion arising from an adequate cause, the punishment range is not 5 to 99 or life, it's 2 to 20. And that's where this case belongs, is right there in the middle of 2 to 20. Is it the best sudden passion case ever? 2? No. Is it the worst sudden passion case ever at 20, where there was they chopped up the body and fed it to alligators? No, it's neither one of those things. It's right in the middle. You know it, and I know it. Is 10 years enough? I don't know. Is 50 years enough? I don't know. But it's in the middle of the range that the law requires. It's a 10-year sentence. And I walked away and I shut the fuck up, and they gave him 10 years.
That's crazy, because I mean, I would have just presumed life after watching that video. It's just that bad.
And we explained this on another one, but it was actually worse than the video because, as I mentioned on a prior episode, he's the only client that's ever walked into my office, and I came to the conclusion that day, dude, he's going to prison. It might be for 2 years, it might be for life, but he's going. There ain't no ifs, ands, or buts about it. He is going. So you do what any lawyer would do and prepare your client for the worst. Tell him to sell your shit, you're going to prison. So he did, and he was living in a hotel, and his son came and visited him because they knew we were going to plead guilty and he was going to go to prison. We didn't know for how long. And the son, and all this is on the videotape, or his statements that came into evidence, so I'm not violating a privilege that some suggested I'm violating, whatever. And his son, they were drinking. I love you, Dad. I love you, son. Kerry expected his son to walk out of the room. Instead, his son blew his head off right there. And the police showed up, and Kerry said, me and my wife got into a little disagreement in the driveway. Yeah, a little disagreement. I've hired this lawyer named Dan Cogdell. We're going to go for sudden passion. Tell him the whole defense, and then the coup de grace. And the jury heard all of this on the body cam. All of this. Why couldn't it have been my other son? This was my good son. I mean, most jury, my whole job description was just keeping them as rational as I possibly could. And the only way you can do that is to, as we say in the criminal defense word, hug the turd. You got to own the turd, dude. It's yours. You can't polish it. You can't bronze it. You just got to hug it.
So knowing when not to cross.
Yeah.
We'll close with this.
Look, my rule is, if the witness doesn't hurt you, shut up. Why do I want to cross-examine a witness that doesn't hurt me? Some witnesses, there's some expert witnesses that will probably hurt you more on cross-examination than on direct examination because they're primed to do so. They're laying in the cut, and anything you ask them, they'll cut you. The hand grenade witness, as I call them, they're going to blow up. You just don't know on who. So I don't want to be the one to pull the trigger on them. The usual case, Aaron, is they're highly emotional, and they're upset at the state for making them testify. They're upset at you for having to be there. They're going to go off. And sometimes it's like, Thank you, ma'am. Nice shoes. You know, just walk away. And the business records custodian, what are you going to get out of that? And then the widow of a parent of a victim. Yeah, I've seen lawyer after lawyer try to get some sympathy or understanding or some concession from the widow or a parent of a victim. They're never going to say anything nice. They're never going to say their daughter was promiscuous, or their husband was an asshole, or their husband. They're never going to say any of that. So what I usually say is, ma'am, I can't imagine what you're going through. I apologize. I apologize on my behalf for your experience and having to even come here. I am so sorry. I wish you the best day you can possibly have, or whatever, and get the fuck out.
Wow. Yeah, I mean this is a series that we're going to start implementing more on Dan's show. Is really kind of getting more into the weeds, and this episode was kind of in cross-examination, but there's so many different aspects in the courtroom and the practice of law in general that obviously Dan has the reps and experience in, that he can kind of educate and share these stories with us because they're absolutely fascinating, and there's a lot to learn. And even I was tearing up and laughing earlier how much how funny it was kind of discussing pauses and maybe jokes that didn't land. But I think we're at time.
Are we done with the slides?
Done with the slides?
Yeah.
Yeah. Jennifer Fitzgerald's ex-boyfriend abandoned a car in the employee parking lot of O'Hara Airport where it was accumulating over 678 parking tickets. Fitzgerald claimed she couldn't access the lot to remove the car. Even after the state of Illinois revoked the car license plates, the city continued to issue tickets. Fitzgerald sued the city to clear the fines and penalties, arguing she shouldn't be responsible for tickets on a car she couldn't be able to reach. The case was settled out at court for $4,500. This situation highlights issues with abandoned vehicles and the complications of handling fines when access to car is restricted. But what a way to get at your ex.
I mean, you got to give him credit. That's pretty clever. And there is such a thin line between love and hate, and the anger and the wrath that people want to put their exes through is never ending in terms of its creativity and it's sometimes it's humor, sometimes it's tragedy, but
thinking outside the box.
Thinking outside the box because of his ex-box. That's for sure.